Well, happy Wednesday. It's Illinois in Focus Daily with America's Talking Network and the Center Square. I'm Greg Bishop, Associate Editor for the Center Square. Got several segments for you. We're going to talk about two different Illinois Supreme Court decisions that came down last week. One impacting the firearm owner ID card. Another impacting the smell of cannabis and whether or not that passes the smell test for officers to be able to do a warrantless search of a vehicle during a traffic stop. But sandwiched in between that, we're going to talk with State Representative Adam Niemerg. He is a co-sponsor of a measure that was filed to prohibit and add criminal charges to non-citizens who register to vote or those who knowingly register non-citizens to vote. So we'll talk with him about that as well. If there's time, we may also delve into food safety. The Secretary of State earlier this week talking about food safety. So several big things to get to here with Illinois in Focus Daily. Like, subscribe, hit that notification bell. Join us each and every weekday morning here as we give you the live show where people are taking part in the live chat. We started about 8 o'clock in the morning, so you can hang over with America's Talking Network and follow us live. And of course, we do record the segments locally so that we can then upload those so you can just go straight to your segments that you may have missed if you didn't make the live show. But again, like, subscribe, hit that notification bell with America's Talking Network here on YouTube. Get Illinois in Focus Daily anywhere you get your podcasts. And coming back, it's time to look at the latest case concerning the firearm owner ID card in the state Supreme Court and the Supreme Court issuing a ruling. We'll unpack that all here with Illinois in Focus Daily.
Statute has not been repealed. If they were to be charged similarly in the future, they would be subject to the exact same prohibition. Thus, they have standing.
That is Attorney Thomas Magg during comments in front of the Illinois Supreme Court earlier this year when they argued two of his clients had their FOID card suspended improperly because they were only charged with a crime, they weren't convicted of a crime. And the Illinois Supreme Court essentially tossing the case out over issues of standing. What does all that mean? Well, we'll tackle that here with Illinois in Focus Daily. I'm Greg Bishop. Of course, like, subscribe, hit that notification bell each and every weekday morning, breaking out some things for you to know here in Illinois. So this case brought up through the court system, and it deals with the FOID card and a couple of individuals who had a FOID card, I believe a father and son. If I recall, they were approached by police who said that they had a report of an improper discharge of a firearm during some kind of celebration, and Ultimately, they were charged with crimes, but they were pleaded down to misdemeanors, and therefore their FOID card shouldn't have been revoked. And regardless, about a year or so, the FOID cards were revoked, and the case went all the way through the circuit courts, the appeals court, and all the way up to the Illinois Supreme Court. And I do want to get right to their conclusion here, and then we'll hear some of the arguments that were made during the trial. The open, or not, it wasn't a trial, it was the full panel of the Illinois Supreme Court hearing these arguments. But here's ultimately what the Illinois Supreme Court said on this case. For the foregoing reasons, we vacate the circuit judge's judgment, holding that section of the FOID Card Act is unconstitutional as applied to persons charged with a felony but not yet convicted of a felony, and enjoining the suspension of FOID cards as to those persons. In entering this disposition, we express no opinion on the merits of the parties' other arguments. As we are vacating the circuit judge's judgment in favor of plaintiffs, they are no longer the prevailing parties, so we also vacate the circuit court's order granting plaintiffs' petition to recover costs and fees. The cause is remanded to the circuit courts with directions to dismiss plaintiffs' First Amendment complaint. All right, where a plaintiff has no standing, the proceedings must be dismissed. This is so because lack of standing negates a plaintiff's cause of action. So, again, they didn't address the issues. As the Supreme Court said, in entering this disposition, we express no opinion of the merits of the parties' other arguments. But what were those arguments? Let's get right into it. Again, this was heard back in May in front of the Illinois Supreme Court here in Springfield. And Attorney Thomas Magg, he laid out the crux of the case in general terms.
There is a federal statute, 18 U.S.C. 922, in as in Nancy, I believe it's the exact quote, that prohibits persons charged but not convicted of felonies, not from possessing firearms. They can keep the ones they've got while they're under indictment or information, but prevents them from acquiring new firearms while they're under charge. That is what this case is about, is the state police interprets, and I think it's a reasonable interpretation of the statute, aside from constitutionality issues, that triggers the section N of the FOID Card Act, which requires suspension of FOID cards when a person cannot acquire a firearm.
So there was some discussion as well during the court proceedings in May in front of the Illinois Supreme Court about the U.S. Supreme Court precedents in cases like the Bruin case, the New York State Rifle Association v. Bruin case. And the attorney representing the state said the law in Illinois for the FOID card, as is being challenged in Magg's case, they say they're good with it. I mean, they're covered.
The Supreme Court is clear that the Second Amendment covers possession of firearms for self-defense by those considered law-abiding and responsible and not dangerous. This does not cover the plaintiffs because while they were under this felony charge, they had conceded that there was probable cause that they recklessly endangered others with firearms.
And again, the case centering around two individuals who fired off their weapons, I believe, into the ground during a celebration of sorts, and police being called and them coming in and arresting the two. But the attorney for the state also talked about the Bruin test and the importance of finding analogous laws from what era exactly?
And then more broadly, the Bruin very clearly explains that the historical law and the modern law do not need to be identical. And the analogs that we presented here, obviously they're not identical because, it's been 250 years, but they're historical analogs about restricting a person's possession on a temporary basis, on, some in a categorical sense and some based on some legal process that is short of a conviction. Kind of with all of those different approaches, there clearly is, a historical basis supporting this law under the Bruin standard.
According to the attorney representing the state, but Attorney Thomas Magg, representing the two individuals who had their FOID cards suspended for merely being arrested, not convicted, here's what he had to say about finding analogies in which era.
To look back at what the law was, depending on which sources you read, either at the time of the adoption of the Second Amendment or arguably at the time of the adoption of the 14th Amendment. I think the time of the Revolution is the more appropriate standard myself, but I understand there is some argument in the literature on that. And prior to 1925, as near as I can tell, there were no restrictions on even actual convicted felons possessing at least long arms.
So again, these arguments about analogous laws from the past are really driven by the U.S. Supreme Court's decisions saying that you have to look at the text, history, and tradition. And analogous laws from when exactly? Is it 1925? Is it 1864? Is it 1796 or 1776? So I think that's obviously something these courts are continuing to hash out, and we'll see a lot more on all kinds of different issues when it comes to the Second Amendment and what kinds of laws may be referred to from the past to justify having a law in place now, or the arguments that, hey, these weren't in place at all when the founding documents were penned, therefore they're unconstitutional. I mean, those seem to be really, at least the history, text, and tradition aspect of finding analogous laws, similar laws. But the issues really in this case, as we read in the conclusion from the Illinois Supreme Court in the opinion they issued on Thursday, saying that this particular law that's being challenged is moot, essentially. Here's the attorney representing the state talking about mootness and what's called standing. Does somebody actually have an injury that they can prove to show that they are the person to bring this case?
But then my final point, just to go back to the issue of standing, because again, that's really what the threshold issue of this case is about. The plaintiffs argue that they have standing because their FOID cards were revoked for nearly a year. But as this court has said, when we're talking about a declaratory judgment, seeking prospective relief, challenging a statute, there must be more than just, the courts use the language, a wrong committed and an injury inflicted.
So what's the injury, though? That was something else that was debated in the hearing in May. You had Chief Justice Teese asking Thomas Magg about where is this injury?
Where is the injury that triggers the ability to have bring a case that looks into the future?
The injury that triggers it is the revocation of the FOID cards.
In the past?
In the past.
Okay. I mean, that's trouble. I mean, you can see what we're saying. This lawsuit looks prospectively. It doesn't look back. It doesn't say, I was injured, therefore I have damages. It looks forward. What will happen in the future, correct?
It is seeking to prevent a similar injury in the future because of the damage that took place in the past.
So interesting arguments there, right? I mean, again, they were injured for about a year, he says. They didn't have their FOID card. They weren't convicted of anything. They pled guilty to a misdemeanor, which doesn't allow for the FOID card to be taken under some circumstances. So he's wanting to bring this case to say, listen, that provision of the law is still in place, and somebody else down the line can very easily be ensnared by it and injured by it. And that's why they're bringing this case from two individuals that had an injury, he says. But they don't now, right? Even when this case was filed, apparently they had their FOID card reinstated. Justice O'Brien raising that question about what's considered a live controversy.
But the fact of the matter is, at the time that this suit was filed, both of these individuals had active FOID cards. Is that accurate?
That is my understanding.
And that when that was challenged in the motion to dismiss and the motions for summary judgment, in the order of the trial court, the judge doesn't address that. He goes,
In this case, my clients, the appellees, actually had their FOID cards actually suspended for approximately a year, plus or minus, because of the imposition of this statute. The statute has not been repealed. If they were to be charged similarly in the future, they would be subject to the exact same prohibition. Thus, they have standing.
and didn't seem to sway the Supreme Court. I think it was a near unanimous decision in this case, with all the justices essentially saying here, again, we'll look at the conclusion in this 10-page report here that they put out the orders for. It says that for the foregoing reasons, we vacate the circuit judge's judgment holding that the FOID Card Act is unconstitutional because a lower judge said it's unconstitutional as applied to persons charged with a felony but not yet convicted of a felony, and enjoining the suspension of FOID cards as to those people. And entering this disposition, we express no opinion on the merits of other arguments. But the state, again, they said that the timing in this case is really where this is all about.
Yes, it's sort of an issue of timing. So because the plaintiffs had their FOID cards when they brought this lawsuit, there was no standing, and the inquiry just kind of ends there. If the plaintiffs had brought their lawsuit while their FOID cards were revoked, then we would have kind of a mootness issue. And I suppose if the court were to overlook the lack of standing here, it would then need to address the mootness issue and the mootness exceptions. But because those exceptions don't excuse a lack of standing, the court need not even reach those exceptions if it rules on the issue of standing.
Bottom line, this case not really going the way that the plaintiffs wanted it to go. And the Supreme Court of Illinois not really taking a position at all on the constitutionality of the firearm owner ID card, other than to say that the lower court's ruling is overturned and vacated. So we'll see what happens next with the FOID card here in Illinois. It's been around since, 1967? I got to do a deep dive into the legislative history of that. Follow me anywhere. Just search Bishop on Air. Like, subscribe, hit that notification bell for Illinois in Focus Daily with America's Talking Network here on YouTube. Stand by as we prepare for a live guest. voting is literally right around the corner, and there's a lot of concerns about voter integrity, including voter data. Is that exposed online? Are malicious actors able to get that and request people's mail-in ballots? What about on the ground? Are non-citizens able to vote in the state of Illinois? We'll talk about this with some voices from both sides of the aisle. Late last year in October, I asked State Senator Robert Martwick about non-citizens voting. Going back into the archives, we'll share some of his response there, and he ultimately said there's no federal law that allows for non-citizens to vote, but discussed ways that non-citizens in Chicago, for instance, can provide some kind of, feedback for school council races. So we'll hear that. But first, I wanted to get live with here State Representative Adam Niemerg, who yesterday announced that he's jumping on as a co-sponsor to State Representative Dan Calkins' bill to address non-citizen voting and making some of these actions felonies. Representative, thanks for taking time with us here with Illinois in Focus Daily. I guess just give us the bottom line here. What's this bill all about?
Well, this bill is very simple, Greg, and thanks for having me on this morning. It is a Class 4 felony if a illegal knowingly votes, or if an individual knowingly registers an illegal immigrant to vote. So it's very, very simple. And with this issue being so politically charged, especially at this point in time and over the last few years, I think it's time that we pass legislation like this to safeguard elections and for the future of this country.
Do we have any examples where we're seeing non-citizens getting registered to vote? I've seen headlines from other states, but are you familiar with anything in the state of Illinois where that's currently happening?
Well, we see it all over the country. We see in Oregon where the DMV registered illegals to vote based on state IDs and driver's licenses. We see in the state of Illinois, the Real ID was changed last year to give illegals driver's license. We see the SAFE Act. So Chicago is a sanctuary city and the state of Illinois is a sanctuary state. It's a situation where we all know where this is heading. We have open borders. We have at least 12 million illegals that have crossed since 2021, and that's just the encounters. So it's a situation where we all see where this is going. We see the ICE facilities being closed throughout the state of Illinois. We know that this is a massive Democrat voter registration drive. And if we do not get ahead of this, they will be allowed to vote. Illegal immigrants will be allowed to vote. You look at in D.C., where just this summer, 158 Democrats voted against a bill to deport illegal immigrants who've committed sex crimes. In July, House Resolution 8281 required citizenship to vote, and 198 House Dems in D.C. voted against that measure. So we all know where this is going. We need to safeguard our elections here in the state of Illinois.
State Representative Adam Niemerg with us here on Illinois in Focus Daily. And in particular, I mean, obviously, you guys don't come back until after the election for fall veto session if you guys do anything at all. So, I mean, what's the likelihood of this getting anywhere, especially coming from, Republicans, where you guys are the super minority?
The truth of the matter, folks, everybody that's listening, is that it probably won't go anywhere. The Democrats have a 78-40 supermajority. We see the legislation that they continue to pass. We see the budgets that continue to pass, where we're upwards of $3 billion spent just on illegal immigrants, healthcare, and housing that we know about here in the state of Illinois. I still can't get a true dollar figure on that. While our populations, our veterans are hurting. The African-American community in Chicago is fed up with this. They're not getting any support in the city of Chicago anymore. All of the monies are going towards illegals. So it's a situation where we really need to watch what's coming. We really need to look at the dollar figures that are being allocated towards illegals. And we had a $900 million tax increase on this budget just this year because of the monies being allocated for illegals. So in the state of Illinois, obviously, it's not going to go anywhere, but we need to keep filing bills like this. And as Republicans, we need to stand united against illegal immigration and safeguard our elections and safeguard our communities against this massive flood of illegals that have been coming in exponentially, especially since the Biden administration has taken office and the Pritzker administration working hand in hand with the Biden administration. So we can't sit idly by. We need to raise awareness, and there are great people within these Dem districts that can bring up this particular bill with their legislators and say, we want action on this issue.
I've seen some pushback on this idea, especially with what the U.S. House has moved forward on saying that, they want non-citizens prohibited from voting, making it crystal clear in congressional statute. But some of the pushback I've seen is this seems to be demonizing migrants who are here, and just the various classifications. You got, the asylum seekers, which could go 4 to 7 years before they even have an asylum hearing. But you've also got those with temporary protected status, like some of the Haitians or some of the Venezuelans, who are here legally, quote unquote, but they're not citizens. So some push back and say, this is an effort to demonize those migrants who are here. What's your reaction to that?
It is absolutely not meant to demonize migrants who come here legally and want to go through the process of becoming citizens of this great country. I am all for legal immigration. That is a tactic that's being used by the left to pursue a political end of allowing illegals to be able to vote. It's all about power and control with the Democrats. If they have another voting bloc that they can bring into this country, that they can have vote in our elections, that they can put on the entitlement program saying, hey, come here, we'll take care of you. We'll give you free housing, free health care, free cell phones, free everything. It tears down the fabric of this country because folks need to come here legally. They need to go through the process. They need to have pride and dignity in coming to this country and becoming citizens and becoming hardworking individuals that will pay into our tax system rather than taking from the tax system. So no, I think that's a fear tactic that's being used by the left to pursue a political end. And I am all for 100% legal immigration. I want this country to prosper, and I want folks to come here legally.
State Representative Adam Niemerg, and finally here, before I get to the clip of State Senator Robert Martwick talking about non-citizens being able to provide input to where, their kids go to school, say in Chicago. Your thoughts on that? I mean, they are obviously having children in schools in Chicago. Should they not have a voice when it comes to, like, for instance, local school council races in Chicago?
Well, it's just another step. It's another step for these folks to be allowed to cast votes, whether it be on the school board level. And in the school board level, there's a lot of money. There's, I think last time I checked, it was pushing $100,000 being spent, if not more, on these Chicago school board elections. So this is very serious. So that is at a smaller level. But if we allow folks to just continue to vote, to say, hey, we're going to allow them to vote in small school board elections, then maybe municipal elections, then state elections and federal elections. And it just keeps going and going and going. And furthermore, ISB was asking for additional monies. They just had a line item in their budget that just said newcomers. So again, I am all for legal immigration. If somebody wants to come here legally and they want to go through the process, 100%, that's the correct way to do it. But for folks to come here illegally, is absolutely wrong, and to get the benefits that everybody that is a legal citizen of this country, of this state, is wrong. For example, I wouldn't go to a different country and say, hey, now I want to live in this country, and furthermore, I want to vote in your elections, and I will do it so illegally. That doesn't happen. No other country does that. So why should we be doing that here in the United States?
State Representative Adam Niemerg, one of the co-sponsors of House Bill 5875. You can go to ilga.gov and type in HB 5875 and find that. It looks like you've got several Republicans signed up as sponsoring this as well. And obviously, we'll get some reaction to it and see where this ultimately goes. But greatly appreciate you taking time with us this morning. And we'll talk again in the near future, all right?
Sounds great. Thank you for having me on, Greg.
All right. It is Illinois in Focus Daily, and I did want to give you also what State Senator Robert Martwick said in the line of questioning I had for him back in October of last year. He was talking about getting the Chicago School Board set up to be elected and the maps that they were hoping to get into place. But I asked him about how non-citizens play into this because, again, non-citizens in Chicago, people want them to be able to sound off on school board races. These are local races, not to be conflated with federal races and federal elections. But here's some of the question and answer from State Senator Robert Martwick from October of last year. Dan, where's that audio? Let's make sure we got that on here.
If you could refresh my memory, the status of non-citizens being able to vote. They can.
So there is nothing in the law that permits non-citizen voting. There is a process where non-citizens can weigh in on the administration of resources in their local schools through what we call local school council elections. They're not official elections, but non-citizens can vote in those elections in the process that they've set up through CPS, and they can participate as candidates in those elections.
Is that going by the wayside with the new
That is not. That is not. The new school board was designed to really connect the school board on a more granular level with those local school councils and make their work, elevate their work, and make it more effective. And that's our hope, is that's what will happen. So there is nothing that allows in the law for participation in the normal course of elections by non-citizens. There's been legislation filed. There are many people that support it, including myself, but there is no legal way to effectuate that at this point. So there is things that are being done. With this legislation, there was the creation of an advisory council that will allow non-citizens to advise the city council on issues that specifically affect them.
And for those who may say,
Excuse me, the elected school board. I said the
for those
city
who may say,
council.
why should non-citizens be allowed to vote or have any say in this? What would your response be?
Well, the schools serve them. They are taxpayers. They are paying taxes that affect that go directly to those schools to educate children from their families and from others. And so I think that I think in a perfect democracy, all those affected by the governmental decision should have a way to weigh in. But currently, in federal law, there is nothing that provides for that.
So again, just some of the conversation around the idea of non-citizens being able to vote, or trying to prohibit them to vote, or do we make it a Class 4 felony for anybody who is a non-citizen registering, or for anybody who knowingly registers a non-citizen to vote? We'll watch that bill closely as well. It's Illinois in Focus Daily. Like, subscribe, hit that notification bell each and every weekday morning here with Illinois in Focus Daily on America's Talking Network.
The odor of marijuana is now an aroma of legality. The odor of cannabis emitting from a motor vehicle standing alone no longer provides a law enforcement officer with probable cause to believe that the vehicle contains evidence of a crime.
And meaning the odor of cannabis no longer passes the smell test. That is some of the arguments from earlier this year in front of the Illinois Supreme Court about a case concerning an individual pulled over for speeding. Cop smelled cannabis and then proceeded to conduct a search on that based on probable cause. Of course, the argument going all the way to the Illinois Supreme Court earlier this year in January, hearing that case. But on Thursday, they released this opinion that really sums it all up here. It says in January 2020, the use and possession of cannabis is presumptively lawful, subject to certain restrictions. And they say, we hold that the odor of burnt cannabis alone is insufficient to provide a probable cause for police officers to perform a warrantless search of a vehicle. So, meaning, if a cop smells raw cannabis or cannabis smoke, they can't use that as the only reason to be able to get into an individual's vehicle and search. So let's hear some of the arguments here. It's Illinois in Focus Daily. I'm Greg Bishop, and you, of course, can like, subscribe, hit that notification bell with America's Talking Network here on YouTube. Get Illinois in Focus Daily anywhere you get your podcasts, and let's get to it here in this short segment about the smell of cannabis no longer passing the smell test when it comes to traffic stops. Here's the Q&A with Justice O'Brien and some of the litigants in this particular case.
How does that play into the odor-proof container when the smell isn't coming from a container or coming from an object, but coming from the person himself?
And this is the response from the attorney representing the state.
Herself.
Sure. So it's important to distinguish the two cases here. One dealt with raw cannabis, in which there was certainly no testimony that the smell came from the person. The officer testified that it came from the car. The second case dealt with smoked cannabis, which I think is probably closer to your hypothetical, which also was not the testimony in this case here. The testimony here was that the officer in Mr. Redmond's case approached the vehicle.
But my question to you was, if it came from a person, if the smell was coming from a person as opposed to an object, how does that play into even the vehicle code, where there is no prohibition against having the smell on the person? So that isn't illegal itself. So how does that establish the probable cause to search?
Sure. So I think all of the acts prohibit the use of marijuana in a vehicle. And that someone smells like a vehicle is certainly one factor of the totality of the circumstances, that cannabis has been used recently, and if a person is traveling in a car, that it may lead a reasonable officer to suspect that the cannabis was used in the
But your
vehicle.
argument is
So again, just some of the questions here, and that was the attorney representing the state, and he really hammered home the issue of, while cannabis may be legal for medicinal and now recreational purposes, there are restrictions on where it can be consumed. You can't consume cannabis and be under the influence while you're driving. You can't have open cannabis container. It has to be in a sealed, odor-proof container, and I think that includes the vapes, so not just the raw cannabis flower. So here's more of the attorney for the states talking about those provisions in law and why they say that it allows for police officers to smell cannabis and then conduct a search.
Raw cannabis would lead a reasonable person to suspect a violation of the odor-proof requirement found in the vehicle code, because necessarily the smell of raw cannabis emitting from a vehicle is not being carried in an odor-proof container. It's obviously proof that there's cannabis in the vehicle, and then that you can smell it is indication that it's not being transferred or transported in an odor-proof container. There's no testimony that it is impossible to comply with the odor-proof requirement provision, and that's clearly not the legislature's belief, because they enacted the odor-proof requirement in 2019 at the exact same time that they put in place the now full legalization system.
So you've got the states laying out their case, and then you had the various individuals representing those who had their vehicles searched after a police officer smelled cannabis. And this particular attorney, Bruce, what was his last name? Bruce Carmen. He laid out that, listen, the probable cause is justified if the evidence that is used for finding probable cause is not subjective.
Olfactory senses aren't like the other senses. Stout came out of what is called the plain sense doctrine, which is you have to plainly sense, see, hear something for there to be probable cause. Smell is not like that. You can't take a picture of a smell like you can objects that you see in plain sight. You can't record on an audio a sound you might have heard, for example, someone showing evidence of impairment. Smell is entirely subjective.